Close enough. Good evening and welcome to the monthly meeting of the Arlington Board of Zoning Appeals, also known as the BZA. I'm Judy Freshman, Chairman of the Board. The Board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Intamalis, Paul Melnick, and Peter Owen. Also present is the professional staff, including Sam Emba, who serves as Acting Secretary to the Board of Zoning Appeals, Arlo Vaughn, Zoning Administrator, Simon Keynes, Administrative Technician, and Blake Bowen, Assistant to the Zoning Administrator. We thank you for being here and extend you a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen the report for your case, that you get a copy and review it before your case is called. The Board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the County Board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the County Board. This Board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from specific requirements of the zoning ordinance, and we could decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the Board find that the proposal meets conditions and that the permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plan and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria. The strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or granting the variance would alleviate a hardship due to a physical condition related to the property or improvements thereon, and the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant, that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not of so general or recurring in nature as to make reasonably practicable the adoption of an amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. When deciding appeals of the zoning administrator, the Board must use its judgment to determine if the administrator was correct. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, Board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the Board may permit the applicant a brief opportunity to clarify any points. The Board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient. 5 minutes for applicants for use permits and variances. For use permits and variances, we have deemed 3 minutes for representatives of organizations and 2 minutes for individuals as being sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Case number V-11238-17-VA-1, a variance request to permit a building footprint of 35.7% and total lot coverage of 47.9% for a new 2-story addition with an attached garage for property in R8 zoning district and premises known as 6100 31st Street North. Staff recommendation. Staff recommended that the board accept the applicant's request to defer the case to July 2017.
Thank you. Mr. Smith?
I move that the Board of Zoning Appeals defer variance July 2017 meeting of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Ms. Malice. All those in favor?
Aye.
Thank you. Next case.
Case number V-11238-17-UP-1, a use permit request to permit a setback of 23.2 feet to the wall from the North Ohio Street right-of-way instead of 25 feet as required, and to modify a previous variance approval that permitted a setback of 16 feet to the North 31st Street right-of-way and 10.8 feet to the North Ohio Street right-of-way for a front porch. For a new 2-story addition with attached garage and enclosed front porch in R8 zoning district on premises known as 6100 31st Street North. Staff recommended that the board accept the applicant's request to defer the case to the July 19th, 2017 meeting.
Thank you. Mr. Smith?
I move that the Board of Zoning Appeals defer the use permit in V-11238-17-UP1 to the July 19, 2017 meeting of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for deferral. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Case number V-11084-17-UP-2 for a use permit request to permit a setback of 6.5 feet to the wall of the home from the left side property line instead of 8 feet as required, and an aggregate side yard of 16.5 feet instead of 18 feet as required for a 2.5-story single-family home with a rear deck. The staff recommends that the board adopt the attached resolution granting the use permit for a setback of 6.5 feet to the wall of the home from the left side property line instead of 8 feet as required, and an aggregate side yard of 16.5 feet instead of 18 feet as required for the construction of a new 2.5-story single-family home with conditions.
Thank you. Questions for staff?
Yes.
Hear from the applicant, please. Sharon?
My name is Lyndall Joseph. I'm the architect. Sharon Singh is not here this evening, but her Elizabeth Paris is here, if you'd like to hear from one of the owners.
Well, first of all, we needed a speaker slip from you.
Pardon?
We need a speaker slip from you in order for you to address the case. Is there no one here to address the case? Okay, you may proceed, but as long as you complete that and give it in
Yeah,
for
I
us.
have
Thank you.
one.
She represent the owner?
Are you representing the owner?
Yes,
Okay.
and I'm here to answer any questions that you have. I appreciate the board's consideration of this measure. It was approved last year, and because the property entered into probate, we were not able to start construction prior to the expiration of the approval.
Questions for the applicant or the representative?
Staff, I guess it was, so you are no longer doing the deck?
Yes, we are doing the deck.
I guess it's a wording issue I have here. Is the deck, it says that is no longer seeking relief for the deck.
Yes, they did made a setback to meet the 21-feet requirement, so which is in the previous application approval, the deck was part of the approval. So in this case, they choose to make the deck to comply with the 21-feet requirement from the rear property line.
I'm not sure that was, I mean, the plans that we have for the deck have not changed.
In the previous application, you would ask for 20.4 feet to the deck from the rear property line instead of 21 feet as required.
Have you seen the staff report?
Yes.
I'm a little just confused about in your view, the deck is now compliant and the use permit is not required for the deck?
Yes, for that part of the deck, yes.
For that part?
Oh, okay, I understand. Right. I mean, the way it's represented here in the staff report is correct on the plat. The deck was 21 feet from the rear yard property line. That's correct.
Okay, so we're in agreement. That's correct?
Yes.
Okay. If you stand by, please. We have a speaker, Giovanni Pendili.
Is that the button? Is that the button?
Go ahead.
You can raise the platform if you...
Oh, that works. It's all right. First time I've done this, so I'm new, so please be gentle. So anyways, I'm a neighbor, and they did come by a long time ago, and I never really gave much thought to them asking for the extra space on the side. And there's a ton of new construction in our neighborhood, Beacon Crest, BCN, everybody, knocking down the old small houses, building the new ones, and nobody, and all the new 20-some neighbors I've met, nobody's asked for something, an exception to how wide the houses can be. We're already stacked on top of each other pretty much, you know. And so I didn't think about it, and it actually dawned on me once I saw the sign up on my post out front, and I said, you know what? Something occurred very recently on our street, directly across the street from this house at 928. A nice lady named Rita moved in, elderly lady. She had BCN build a house for her on actually a smaller lot. And initially when the architect, which was a very nice lady, came by, said, hey, we want this extra space because we're putting an elevator for an elderly lady. I said, well, that makes sense, you know. We don't have an elevator, but maybe you need extra space. I don't know. I'm not an architect. But I went for Thanksgiving over to Rita's house across the street from this dwelling, and she has an elevator. And then a garage in her basement, 4 beautiful bedrooms, and a smaller lot, and she didn't ask for extra space. And I thought to myself, this sets a bad precedent in our neighborhood, right? I mean, we're already stacked on top of each other. Unless there's a real compelling, a hardship, I think is as you described it, a hardship or a compelling reason to encroach on your neighbor, it doesn't seem like it should be allowed. You know, I can understand if the lot was narrower than all the other lots, but it's the same with the Rita's. And she has a beautiful integrated garage, elevator, like I said, everything. So I can't understand that there's a hardship or a real reason why. And of course, I also know that Arlington is dogged in their pursuit of stormwater management. And I would think that this would also create a larger non-permeable footprint for no reason. So I think it runs into, you know, the ethos of the county there. There's no hardship there. So, you know, we're going to have 4 or 5 more knockdowns. So now is the next knockdown say, oh, well, you know, they did it for no compelling reason. Should I? So My thought is, unless there's a real compelling reason, it shouldn't happen. Thank you.
Thank you.
Excuse me, could you state your address?
915.
915
915, 2 doors down to the left.
on the same street.
Yeah, you guys just fixed my sidewalk today. Thank you.
915.
So you had signed the petition before?
My wife did, and I didn't know it.
Okay, got it.
Mr. Owen.
Just for clarity, we don't fix the sidewalk. We just do zoning appeals. The county,
You guys were definitely not there today, but
the county board is the government.
I mean, you guys is in the county.
Adjudicate zoning appeals.
Okay.
Okay, thank you.
Is that it? Well, thank you.
Any other comments or questions of the applicant representative or staff?
Madam Chair, I'm sorry.
Mr. Owen.
Ms. Malice, I think I'll defer to her if she wants to go first.
I was just going through the addresses. I don't see anything for 917.
915, ma'am.
No, this, different person, the next door neighbor.
Yes. She's an elderly lady. Doesn't come out very often, so you might have knocked.
Question is to the applicant.
Also, 923, the budding neighbor to the north, was not on either this petition this time or a year ago. I'm curious about what was the efforts made to reach out to that neighbor?
Are you speaking about Mr. Bill Anhut
I don't know the,
at 923?
Owner at 923, just to the north of this property, of the property you're working on.
That property is owned by Mr. Bill Anhut, who's actually 2 doors to the north. He owns, and he lives at that residence. And I sat down, I'd spent a great deal of time with Mr. and Mrs. Anhut. We went over the plans. He's also on the Lions Park Civic Association. And I reviewed the plans thoroughly with him. He was not objecting being on the north side. That's where we're seeking relief from. He was not objecting at all. Now, on the south side, where your property is located, there's no, we're not asking for any relief on that side. And this year I did speak to Mr. Anhut. I offered to make a presentation again at the Civic Association, and he said it was really not necessary since their bylaws prohibit them from making any type of motions about or holding any opinions on zoning matters.
I guess I'm curious, since it looks like considerable efforts were made to reach out to other neighbors and get their signatures multiple years on petitions. And
Right.
Mr. Anhut, I think, by reputation, is a person who sort of knows the game. And so I'm curious about why we don't have Mr. Anhut's signature on either of the petitions.
Well, because he felt that as being on the board of the Lions Park Civic Association, and they're forbidden for having issues or stating positions on zoning matters. I would presume that's it.
I mean, as an individual, he would be able to sign representing his property, right?
Yes.
Without having any,
Well, I mean, he could also. Mrs. Sharon Singh went by his house yesterday afternoon to remind him, too, that the meeting was tonight, and she didn't, there was nobody home. And when I spent the time that I spent with him, over an hour, him and his wife, they had no objections to what we were proposing. So,
Are you representing to us tonight that you either asked or you were present when Mr. Anhut was asked to sign a petition and he declined on the grounds of his civic association affiliation? Is that what you're saying?
no, I'm not going. I'm just suggesting that's why he didn't sign the petition.
Okay.
Didn't sign, I went to his house with the petition and with a full set of plans, 24 by 30 inches printed out on the large paper. I went over the house plans with both him and his wife, and the property they own to the north of us is a rental property that they own and rent out. And they told me what their plans were to build a new home there, similar to the one that I showed him. So I can't tell you why specifically he didn't sign the petition. I'm just assuming that's why he didn't.
Thank you.
Other questions?
It's concerning that neither neighbor on either side indicated their support for the project.
And
Well, the neighbor on the south side, I met with her myself last time. She's hardly ever leaves the house. The neighbors were surprised that she even let me in the front door. And I visited with her and talked to her about it. She had some concerns about the driveway because Mr. Singh was being a good neighbor and had resurfaced her driveway along with his. And I think she thought it was for some reason, she didn't seem to be appreciative of it at the time. But I did my best to reach out to her, and I think I did all that was humanly possible.
So just to further elaborate on that, our decisions are appealable to the circuit court, and they're appealable by people who have, an interest. And so I don't like being reversed, and so it's nice to feel confident that the neighbors who might take this to circuit court are unlikely to do so because we've got some kind of writing from them. And so to have, and I think there's not, if I recall correctly, I think is the rear yard neighbor?
Yeah, I think the rear yard neighbor signed.
Rear yard neighbor is. So it adds a degree of sort of nervousness
Take it back.
for me when, just as a board member, when I don't see that the people most likely to appeal our decision.
Right. Well, as I say, when we went over the plans, they really liked the idea. Our concept was asking for by the extra few feet.
Right.
We were able to make the house 24 feet wide, which does accommodate an elevator and has enough room for like a 12-foot room on one side, a hallway, and then an elevator, allowing that traffic plan from front to rear of the house. And so it doesn't, it's only a small relief we're asking for, but it does make a big difference. And so the Anhuds thought that, they would perhaps like to seek the same relief and be able to do also a 24-foot home for the same reason.
Mr. Smith.
Yeah, I'm wondering if staff has any information as to the width of the lot, which is for 928. The neighbor indicated that they had a new build with an elevator. Caddy corner.
Directly almost across the street, just a little bit.
You're talking about for a different property?
Yeah.
I mean, not with the materials that we have here.
Okay.
On lot 22. I don't have that
That was
information.
that was 928, right?
Yes, sir.
Yeah. Okay.
We're all the same.
That looks narrower.
It is narrow, actually. It's a split lot. I didn't want to go that far because I wasn't positive it was narrow.
Sir? Other
So,
questions, comments?
I do
Mr.
have.
Owen?
In comparing the plats for this submission versus the one from last year, as to the rear deck, it appeared to me on the plat, comparing them just now, that the rear lot line is not rectilinear to the, or not purely parallel to the front, nor to the house itself. So it looks like in last year's application, the deck ran all the way to the north side of the house. But in this application, there's a planter box that's a couple feet on the north side of the back of the house, and the deck is sort of scooched down to the south. And it appears that that's what makes up the other 6-inch difference, because you're now operating at a more southerly location on the lot. So do you think I have that right? I think that I'm correctly understanding why there's a difference from this year and last year?
I'm just noticing that myself, and I'm not sure which plat in the staff report is the most recent one.
Well, the
Sam?
one on the screen is the one that's in our current application.
Okay, yeah, the deck is moved towards the north side.
I think that's moving towards the south side. I think in the last year's application, the deck was flush with the north side, and now it's in the middle.
Yeah, it's withdrawn. It's withdrawn from that corner
Right.
of the north. It's been reduced.
Right. So now that said, that's a little bit, if we're down to the inch, right, one false move by a contractor, and there could be more fees to try and come back to the BZA with a stop work order.
Oh,
So-
right, yes.
So I hope that there will be caution about supervising the contractors with such tight tolerances.
Yes, and I think I'm reminded that now Arlington County is measuring from the outside material of the house to the property line. So I appreciate that reminder. The last time it does make, it is a little confusing at times, because sometimes the civil plan doesn't agree with the architectural plans when I reduce the foundation to accommodate that.
So we heard from a neighbor tonight about whether or not this application meets the criteria that we're required to follow for use permits. And the criteria we're supposed to follow for use permits is different than for variances. For use permits, for variances, to put it very roughly, we're looking for something about this lot that's very different from other pieces of land, usually, right? Something about the land that's differently shaped, or some kind of obstacle on the parcel of land that makes it different from its neighbors. With use permits, again, speaking very roughly, we're looking for similarity. We are looking for compatibility with the style of the rest of the neighborhood. And in the staff report, there's a list of other parcels nearby where lot lines are, where buildings are similarly close to the lot lines as you're proposing on the left and right. Since you're an architect, I'm wondering if you care to speak any further to the compatibility of your design and your location to other nearby parcels, as we are required to evaluate by law.
Well, yes, I would. I mean, there's a number of instances, and in fact, the current structure on the house is less than 2 feet from the property line. So actually, we're bringing it back into compatibility by tearing down the house. We're withdrawing it from its present location, creating light and space in between the house and the property line, which it doesn't have now. there's a number of properties on the same block that are right on the property line. Even the house to the north of us at 923 is practically directly on the property line to their north. So, and I think that's what the Anhits were thinking about when they tear down that house. They realize they're going to have the same issues that we're having, where their home is just as close to the property line as our house is right now. So we're reducing, what we're actually doing is tearing down the house, reducing the width of it to bring it back into that compatibility.
Any other questions, comments? Motion? Mr. Melnick.
Okay, in case V1108417 UP2, I move that the Board of Zoning Appeals grant the use permit as advertised.
Second.
Madam Chair?
Oh, I think
Mr. Owen, yes.
I think I know what he's going to say.
So I'm just, this is another one where an approval was made by this BZA previously. A very similar design was approved and a very similar use permit was approved. And I'm not sure I would be entirely content with the application as it's been presented to us, especially with neither of the abutting neighbors having any writing about them. But following the practice that I have on numerous other occasions, where we're dealing with an expired, one-year expiration, I'm going to vote yes because I think it's sort of the law of the land, the law of the plot. But I just wanted to put out there that if this were an original application, I'm not sure I would have been so sanguine about it.
Thank you. Can I just have a clarification on the motion?
Yes.
Are we talking about the motion recommending approval or as advertised? We have two.
It's the amended application. It's the one that has approval in parentheses after it.
Without the deck language.
There's another one advertised, and that's the one with the 20.4 feet to the deck. So it's
So your motion is approval, not the one as advertised.
exactly. So I submit that clarification.
Mr. Seconder, that's okay? Okay. So,
If I didn't state it with the conditions as stated in the
okay.
resolution.
So the motion as made by Mr. Melnick and seconded by Mr. Smith is the first motion listed, which is shown as approval. Parenthetically, I believe that is without the language referring to the deck. Everybody clear?
So there's no rear property line relief in the motion? Okay.
That is correct. Are we all on the same page? All those in favor?
Aye.
Aye. Thank you. So what is approved is the motion as stated in the staff report, the first resolution. It says resolution paren approval.
Okay, thank you.
You're welcome. And please remember the speaker slip. Thank you. Next case, please.
Case number V-11274-17-UP-1 for a use permit request by Jaji and Sujit Brawler to permit a setback of 2.8 feet to the edge of the roof line to the right side lot line instead of 10 feet as required for a new carport in R6 zoning district on a premises known as 5207 North 11th Street. Staff recommends that this application be deferred, defer the use permit to the July 2017 hearing.
Thank you.
Madam Chair,
Ms. Malice.
I move that the Board of Zoning Appeals defer use permit V 11274-17-UP-1 to the July 7, 2017 BZA hearing.
Thank you. Moved by Ms. Malice, seconded by Mr. Smith to defer the case to the July BZA hearing. All those in favor?
Aye.
Aye. Thank you. Next case.
Case number V-11275-17-VA-1. A variance request to permit a construction on 11th Street South in a non-conforming lot that does not meet the width and area requirement for a new two-story single-family dwelling fronting 11th Street South, for a new two-story single-family dwelling in R5 zoning district on premises known as unimproved lot number 139 on the 1600 block of 11th Street South. Staff recommends that the application be deferred the variance to the July 2017 hearing.
Madam Chair,
Mr. Owen.
I move that the Board of Zoning Appeals in matter V-11275-17-VA-1 defer the variance request consideration to the July 2017 BZA hearing.
Second.
Moved by Mr. Owen, seconded by Ms. Malice for deferral to the July BZA hearing. All those in favor?
Aye.
Aye. Thank you. Next case.
Case number V-11275-17-UP-1. Use permit request to permit a rear deck setback of 15.2 feet instead of 21 feet as required, and 4.4 feet to the window wells instead of 5 feet, and 4.6 feet to the air conditioning units from the left side property line instead of 5 feet as required, 4.1 feet to the stormwater planter box from the left side property line instead of 5 feet as required, 21.5 feet to the rear area way, 7.1 feet to the eave on the left side of the property line, 24.1 feet to the stormwater planters, 24.1 feet to the eave of the front property line for a new two-story single-family dwelling with a rear deck, window walls, and stormwater planters in R5 zoning district on premises known as unimproved lot number 134 on the 1600 block of 11th Street South. Staff recommends that the board defer the use permit to the July 2017 hearing.
Madam Chair,
Mr. Owen.
I move that in case V-11275-17-UP-1, that the Board of Zoning Appeals defer the use permit to the July 2017 BZA hearing.
Second.
Moved by Mr. Owen, seconded by Ms. Malice to defer the use permit to the July 2017 BZA hearing. All those in favor?
Aye.
Aye. Thank you. Next case.
Case number V-11085-17-UP-2. Use permit request to permit a setback of 9.5 feet to the egress window well, 11.5 feet to the chimney, 8.5 feet to the two stormwater planter boxes, and 13.2 feet to the wall of the home from the left side property line instead of 13.3 feet as required, and a setback of 9.5 feet to the egress window well, 11.5 feet to the chimney, 8.5 feet to two stormwater planter boxes, and 13.2 feet to the wall of the home from the right side property line instead of 13.3 feet as required. For a new three-story semi-detached two-family dwelling with two side chimneys, 4 side stormwater planter boxes, and 2 side egress window well in R27 zoning district on premises known as 2003 and 2005 South Lincoln Street. Staff recommends that the board adopt the attached resolution granting the use permit with conditions.
Thank you. Questions for staff?
Chair,
Mr. Owen.
Has the applicant submitted any additional materials since last Friday?
Applicant submitted a revised disclosure statement, which I have here with me, and no additional material have been received as of now. except this
Can
one.
we see the copies of the revised disclosure statement?
Thank you.
Questions for staff?
Yes.
We hear from the applicant, please.
Half of Care Assets. Do you have any questions? Or do I need to present at this point?
Questions for the applicant?
You have no presentation.
The presentation is, this is the same use permit that we requested a year ago. We actually shrank the building a little bit more, so we're actually requesting less than what was previously approved upon. We expired past the 1 year because we had some issues with the architect that we were currently working with at the time. He had some personal issues and extended for an extreme amount of time. Then we had to let him go and start with a new architect, which pretty much started the project all over again. So we just kind of ran out of time. We got through 3 submissions with the county here, and again, we just ran over our time on February of 17, I think. And we've submitted everything again. We're pretty much approved throughout on the building side per this approval tonight.
Questions for the applicant?
Madam Chair,
Ms. Rowan?
can you describe the nature of your outreach to the neighbors to the rear lot line?
The rear lot line, I went there twice, once during the weekday and one on the weekend, and I tried to look at the 3 properties right to the rear of the house. So I think we lot 27, 25, and 24, but I wasn't able to speak with anybody that lived there. I spoke with a child once, but no one that actually lived there at the time.
When did you visit?
It was Tuesday. It was a Tuesday, I can tell you that much. And the first time was the 1st that I went. Yeah, it was the 1st.
First of what month?
June, this month.
Uh-huh.
And then I went back Saturday. I didn't actually really talk to anybody down there. First, and that's Saturday the 10th. Was that following Saturday?
Thank you. Had you guys also reached out to the rear neighbors previous round of application?
Had we reached out to them? Yeah, we had reached out. Actually, the previous owner of this property lives back there, Portia Clark, and so she was well aware of the situation and everything going on. I did not, but when I talked to her previously about it, that we were not in the Board of Zoning Appeals portion at that point, but no, I was not able to speak to her for this time.
Okay. And do you have did you submit a petition to us? I don't think I see it here, for 2009 Lincoln Street? The
As far
property
as a
to the
letter
south?
from the neighbor?
I saw one from 2001, which is to the north.
Yeah, I've got approvals or support from both sides, 2001 and 2009 Syed. It's right here if you'd like me to give it to you.
Yes. What's the name of the neighbor at 2009?
Syed Kasif Rice.
Yeah, I don't think I see that. Am I missing? Do you guys have that? All right. Oh, it looks like they did have it. Thank you. Great. Thank you for making sure we had those.
Absolutely.
Any other questions for the applicant? No speakers? Thank you. Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in V-11085-17-UP2, subject to the conditions that are stated in the staff report.
I'll second.
Moved by Mr. Smith, seconded by Mr. Melnick. All those in favor?
Aye.
Opposed? Right. Thank you.
Thank you so much.
Next case, please.
Case number V-10226-17-UP-2, a use permit request to permit a setback of 13.2 feet from the right side property line instead of 25 feet as required, and an aggregate side yard of 24.9 feet instead of 33 feet as required for expansion of an existing screen porch for a new two-story right side addition in R8 zoning district on premises known as 1422 North Jefferson Street. Staff recommends that the board adopt the attached resolution denying a setback of 13.2 feet. An alternate resolution has been provided should the board wish to approve the use permit as advertised.
Thank you. Questions for staff?
I have one.
Mr. Melnick.
Okay, so in this, I see that in the staff recommendation, it basically says that the requested setback will not make the property compatible with surrounding structures. Does the staff have any information about what generally the surrounding structures have as far as the setback from the side lot lines? Is there anything to compare this with?
Yes, staff did look at the existing building permits application in records. We looked at the plots to find if any of the plots, any of the properties that have any setback close to the property line than what the applicant is requested.
Right.
Staff did not find any. The closest one which staff found was 1503, which we measured to be 16 feet, if I recall, from that property line. That was the closest one which staff found. We could not find anyone which is up to 13 feet from the property line as requested by the applicant.
Okay.
Madam Chair?
Thank you.
Ms. Malice.
And that one that you found is similar to where the existing structure is on this structure. It's approximately this is about
Yes.
where the others are. The closest one you found is about equivalent to this one as it exists now.
Yes.
Which address was that again?
It was 1502. It should be this one.
Yep, that would have been my guess.
I did measurements with the existing plots in record for all of this. I could not find any that was that close. I'm sure it's this one.
Can I just ask a question of staff?
Ms. Malice.
This is unusual, I guess, but when it's a right-of-way question like this, the county essentially becomes the neighbor, affected neighbor. Is that how you look at it? And the county has an interest in maintaining their right-of-way?
Yes, I believe the county has an interest in maintaining the right of way.
Other questions for the moment? Applicant, please.
Madam Chair, as the applicant is approaching, are there any other speakers other than the applicant?
No.
Hi. We're Rachel and Jim Hensler of 1422 North Jefferson Street, and we just want to thank you for hearing our original request for a use permit. We have a 1940 home with a screened-in porch, and the foundation is failing, and the wood is rotting. We've talked to a couple contractors. We have to tear it down to fix it. We can't fix it the way it is because of foundation problems. So in our in our plans to fix it, we were hoping to go up and down to get some more usable space in our home. Down below, to do a basement room, if we stayed on the current plat, our room would only be able to be 8 feet wide. At the most, where our chimney is, it's 6 feet wide. So we are requesting just a few extra feet to make a little bit more usable space in a room in our basement. I've taken the plans to all of our neighbors contiguous to our property and even more, and shown them the plans. They're all supportive, very supportive. They've signed the petition.
Which is where?
You know, our plans were to keep an architectural style of the hardy wood, plank, and brick to match our home and other homes in our neighborhood. We will not be disturbing any trees, any foliage. And, you know, I just want to say I've grown up in Arlington. My family moved here when I was 2, and I used to walk by this house every day to and from Swanson. I grew up a half a mile away, and I never ever thought I'd be living there, but we love this neighborhood and we love our house, and we're just trying to get a little bit of extra space to raise our kids, and that's it.
Question?
Chair, I have a question.
Mr. Melnick.
Okay. So you probably heard, the staff, explain what they found, and what they do is they look around just to see what the setbacks are, what's the closest one, and the staff was saying 16 feet, and that's similar to the way the house currently is, to the right side. So have you explored, any other alternatives with them, to try to be more in compliance? Because it looks like it's 2.8 feet off. But, have you...
With the county, you mean?
Yeah, just to see if there's some, something that they could recommend to try to work this out.
I just became aware of this recommendation yesterday, so no, I have not. But, the original structure is already out of compliance with current zoning, so we're already, that's part of the problem.
Yeah, but see, what we look at is we look at compatibility, and so, what the staff's looking at is, how close are structures, and what you don't want is something sticking out, or being out of place, or being, houses are a certain, in general, a certain distance from lot lines and that kind of thing, and so what he was saying is what he found is they aren't closer than 16 feet, and so that's what I was wondering, is if in light of that, it sounds like if you just found out that recently, then you haven't been able to have much of a conversation with staff.
No, I have not.
Okay.
Didn't realize that was an option, actually, honestly. This is our first time ever doing something in this process.
Okay.
And if you look at other homes on our street, neighboring streets that are built at the same time, similar, several people have done exactly what we want to do, going up and down. It's not uncommon where we are. So.
You said that you only learned yesterday of the staff recommendation. Is that what you just said?
Just printed it. Yeah, I just went online to check the agenda to see where we were. I had a couple of phone calls on Monday from staff asking me questions about previous permits, but there was no discussion at all in those conversations that the staff was going to recommend not approving us with the additional 3 feet that we're asking for.
Thank you. That's helpful to a discussion we're going to have later on tonight. So thank you for that additional information.
Can you repeat when you learned about it? We said, when was it exactly? Was it?
Yesterday when I printed out.
Okay.
You learned about it from the website when you checked it yesterday?
Yes.
Right. And just for your information, that information went on the website on Friday, which in and of itself isn't that long ago.
Right.
So,
But I had 2 conversations with staff on Monday, and it was never raised
right.
by staff. So I had no idea until I actually looked.
I can see how that would be frustrating.
Yeah, I was reading, I was like, wait a minute. I had no idea, because actually in previous staff we were dealing with, because this is like the 3rd person we've been dealing, we've dealt with several people along the way, and the first person we dealt with didn't seem to, my impression was that this wasn't going to be a big deal. So that's why we were taken aback, I'll put it that way.
Some people do have that experience. So,
Ms. Malice.
I actually had an additional question, but I can wait.
Go ahead.
When I was visited your neighborhood this weekend as part of preparing for this meeting, and what I noticed is that your home's configuration is actually not the same as very many other houses on that street, on Jefferson Street. It looks like, because of the way the other roads connect, that to your west, the homes mostly face front to Jefferson Street. And there's only about 4 or 5 homes to your east, and then Jefferson Street basically terminates or takes a jog or something, and so the street basically ends a block from you to the west, or to the east. Is that right? Am I getting that right?
It runs into Washington Boulevard, and then it continues on.
Oh, I'm sorry. I'm talking about 15th Street.
Oh, 15th Street,
15th
yes.
Street does.
Yes, 15th Street does that.
So 15th Street, a block to your east at Ivanhoe, basically terminates.
Yes.
And then to the west, another block away from you, the houses all reorient, and the 15th becomes the street everyone faces.
Correct.
So when I was looking at your request in your block, it looked like there was a relatively small universe on 15th Street in particular that are similar to you, that have basically the side of their house against 15th. And I did actually see, it seemed to me that there was a pretty consistent pattern, that quite a number of your neighbors had either a screened-in porch or window bays, where you might be equivalent to your screened-in porch. But I didn't see any that went up to the 3rd story in that little section.
If you go actually just 1 block over the corner of Ivanhoe and Washington Boulevard, 1400 Ivanhoe, that one does. And I'm trying to think of some others that I've seen. That's one address I remember.
So that kind of information is the key information for us when we're evaluating a use permit, is compatibility with the rest of the neighborhood. So staff did not identify, and when I visited, I did not identify any of those. So depending on how this turns out, I just want to point that out to you, right, that's a criteria for us. It's not just what staff was mentioning before in response to Mr. Melnick's comments about the distance from the roadway, but also what is it that's that distance from the roadway? Is it a 1-story, 2-story, 3-story, right? That's relevant to our decision-making to see is this the furthest reach, compared to all the other houses? So I just wanted to ask about that. Thank you.
Ms. Malice.
The staff report indicates that you had the support of 9 neighbors. Do you have the documentation for that?
There should be a petition in the, we submitted a petition. I can have a copy of it if you need it.
We don't have it there. I think that one came later.
I think I got an email with it but I don't think that you got an email from staff with it. I think I was the,
Got an email yesterday or this morning.
I think only one member of the board got an email from staff with this information.
Number of PDFs attached.
No, it's
Didn't get it
different.
from staff.
I got that from you.
Yeah.
Thank you.
Okay. Any other questions, comments?
I'd like to see the signatures at some point, but I don't know if it's material at this point or not, but for the record.
Yeah, I think she'll have.
It was signatures from,
That's all right. I think they're going to send us something.
okay.
Pass it down.
While we're waiting, I'm ready to have another question.
Mr. Owen?
So there was a 1992 approval, maybe it was 1987 approval, in fact, of a three-story structure at this location. 92. Were
That
you-
wasn't us.
Right, it was a previous owner of your property. So do you have any information, or did you work with staff to learn anything about what was requested and whether that, because it looks like it was requested but perhaps never built?
That was when I had the phone call on Monday. That was the first I'd ever heard of that request. And I knew it was never built when I was asked that question, but I was not aware of that request or that approval.
Are you under the impression that your home and porch as it's currently built is in conformity with your permits, or do you think that it's already over the line? Because you said something that confused me a bit before.
I mean, then if you're looking at 25-foot setback and 25-foot setback because we have two fronts, since we're on a corner, the original porch is already 9 feet into that setback. That's my point.
I see, but this parcel got a variance in '87 that allowed that, I believe.
No, I think,
No, do I have this wrong?
is that what that's for? I didn't know what that was for.
Is the as-built condition today conforming or not conforming?
I believe it is conforming to what the ordinance required when it was constructed. In 1940, the requirement was only for 15 feet.
Okay.
So when it was built, it was conforming. The variances that were granted in 87 and 92 would have allowed additional encroachments, but I don't think they were ever acted upon.
Oh, so even the 87 has expired? Is that what you're saying?
We couldn't find evidence that either of them had been acted on.
Interesting. Okay, so that was what confused me, is that, so what, and did you guys say that you saw plats?
From 1940 or 1950.
The map 1950 map book.
But there were no plats post 87 that you have. Is that correct?
Less for the ones that I emailed you from the staff report. Those are the ones I got. I didn't see anyone post that period.
Okay, so that was what because what confuses me is that the 87 permit, if I'm correctly understanding it, it's not clear to me that the 87 permit was asking for anything different than what we see today. So I'm confused
But I think that's what I'm
about
seeing.
that. Because I have to say that I was, even walking by it, I was a little surprised to see that because you claimed in your application, and I think that's your understanding, is that the porch was original to the house?
Yes.
Okay. And so the brickwork seemed a little bit newer than that to me. Maybe it's been touched up or repointed or something. But,
Yeah, it's been painted and
right.
things along the way.
But,
Yeah, if you look at it now, it doesn't look that good.
but the 87 permit doesn't seem to ask for anything more than that. And so I'm confused why that wouldn't be the controlling law for this parcel. The 92 obviously was not built. 'cause
Way or
that was the
another.
third
I guess the answer is, I can't say with certainty because we don't have evidence verifying it.
Okay.
Other comments or questions?
I'll just say that I think that this process is confusing to many people who aren't confused by a lot of things in life and find this process especially confusing. And so whatever we wind up doing, I hope that you've heard, at least from one person, that there's some sympathy for perhaps we would all learn from your experience and others that we've had in the past about ways that we might make it less confusing for people that follow you. So I don't think you should feel, if you're feeling stressed out and confused right now, I don't think you should feel that's because of a lack of necessarily of preparation on your part. This is also a particularly complex question, what you're asking. It's not, from my perspective, a run-of-the-mill request for a use permit. There's a lot of things going on, including the multiple prior permits, things that were asked for that weren't built, and the nature, corner lots are hard otherwise, precedential encroachments on streets are complex for other reasons, so you have an unusually complex request compared to some others that we get here. And then in addition to that, I think it's hard for a lot of people at this moment who are applying for use permits to feel like they fully understand what's happening, and that's a long-term issue that some of us are trying to talk about. So some of the questions that I asked you tonight were directed towards informing, maybe making it better in the future for people. So I appreciate your patience with those.
Madam Chairman,
Mr. Smith.
I think that the request is actually rather modest, and given the fact that you've got to do something to rehabilitate the structure, you want to take the opportunity to gain more space and go to the second story where others have apparently thought about it and taken a couple of steps toward it but hadn't really fulfilled that. So I would move that the Board of Zoning Appeals adopt the alternative resolution, which is what you requested, and that's in the case of V-10226-17-UP2, with the conditions that are also described in the alternative resolution.
I'm sorry, may I ask a question? Is that, I'm sorry.
Is there a second? I will second. Discussion?
Madam Chair, I am reluctant to move forward on this today. I do see a precedential, we often talk about, how precedents build on each other, and this is, to me, setting a precedent for the neighborhood. I know you can do one-offs because it's on a corner and that kind of thing, but I think this requires more thought.
Mr. Malnick?
Yeah, I'm also hesitant, to approve or to, vote yes for the motion because, the standard is promote, would the proposal promote compatibility of development with the surrounding neighborhood? And what we're hearing from the staff is that, there's at least a deviation of 2.8 feet. And, it's true that, then, generally we look at the graphs that the staff puts together to see, is this within the realm of what what is in this neighborhood? So while it's small and while I sympathize with you, having heard so recently about any issue with the staff, the facts are out here, and we're bound to follow the standards, in the law about how our decisions are supposed to go. And I'd be concerned about precedent too, And maybe, I don't know if there could be any more investigation of staff, because it looks like they only found, you gave one example, but, and also, more conversation with you all and the staff about what the possibilities are about trying to see if what you could do could be compatible with staff could recommend. So I'm hesitant too on this.
May I ask the zoning administrator, since this existing porch is encroaching, is there a problem with rebuilding it as is?
They would still have to come back in to rebuild it in the same location. They'd still need BZA relief. They could repair it, but once it comes down, they'd have to come back and get relief to replace it, even in its existing location.
Well, I think that that's an important piece of information that you may not be aware of as applicants, that if you take it down, even if you built it in the same location, you'd be back here.
I'm a little surprised at the zoning.
Mr. Owen.
I'm so sorry, Madam Chair. I'm a little surprised at the zoning administrator's certainty of that, given the 2007, given the 1987 variance. You're certain that the 1987 variance does not permit this to be rebuilt as is?
Well, I don't know that the variance was asking for the exact same thing that they're asking for now.
Well, not that they're asking for now, but what they have now.
I can't answer that without having reviewed it. If the question is if there's a non-conforming feature and can it be rebuilt as is, the answer is no. If you tear something down that's not conforming, you have to start over.
I agree. I'm not disputing that principle.
Okay, but that's what I was asked.
What I'm confused about is the fact, right? I'm not sure factually that it's clear to me. You're the one whose opinion matters, right? But it's still not clear to me that it's been well established tonight that this is in fact non-conforming with the
previous variance.
The previous variance, right? With the 1987 variance in particular, and I wouldn't be totally shocked to find out that the zoning administrator you might, on further research, find that this particular porch is conforming on this particular site because of that variance. I'm sorry, Madam Chairman, for speaking out of order.
Well, then I think you have a bit of a dilemma here. If there's some legal interpretation that's required even to replace what's there, apart from whether or not the BZA is inclined to grant relief for additional encroachment.
Madam Chair, I'd be willing to withdraw my motion and make a substitute motion to defer until August at the earliest. For the purpose of
Well, as a seconder, I'll accept that, certainly, but you want to move that?
and that would be for the purpose of the applicant discussing with staff what possibilities may exist separate from what the application is that's in front of us, and also give staff an opportunity to look at comparables and
Maybe get the county attorney's opinion on the previous variance.
the 87 variance for a two-story addition that apparently wasn't built. So, therefore, having withdrawn and having the second been withdrawn, I move to defer this matter to the August meeting of the Board of Zoning Appeals.
I wouldn't second that.
Madam Chair.
Mr. Owen.
I just would be interested to hear the applicant's views on whether August is a convenient time for them to come back.
What's the date of the August meeting? Because we will be out of town for the August meeting.
The 9th, August 9th.
No, we'll be out of town.
What's the date of the September meeting?
I think it's the...
And Madam Chair, if I might, this is such a significant project, I think it behooves you and us to take the kind of time necessary to get it right now after somebody fits and starts. It looks like it historically existed in this home that you have seen for the last umpteen years that is such an idyllic story. I think we want to have it done right.
The September meeting is the 20th of September.
Okay.
Is that a convenient day for you?
As far as I know.
Yeah, we'll make it convenient.
Madam Chair, I would ask unanimous consent to amend the motion to move it to the September 20th meeting.
Without objection. All right. Who seconded your motion?
Well, initially you seconded
did.
my motion. Oh, Ms.
Okay.
Wallace did this time.
Thank you.
Yeah, so just to be clear, what we're expecting in the deferral period would be that that staff clarifies sort of the legal basis of these variances going forward, but also that the applicant meet with staff to see if there's other alternatives that would bring you closer into compliance, so that we're more clear about what the alternatives are.
For example, a different shaped addition might better comply with the technical rules. That might be an example of something to look at. Also, I would say that when we do, if it does come back as a apparently precedent-setting encroachment, I'm often interested to know the Civic Association's view, because that's going to affect a wider group of people.
Okay. I reached out to the Civic Association, and they said, we don't really care, that it doesn't really make a difference, but if it does, I'll go back to them.
Thank you. The motion made by Mr. Smith, seconded by Ms. Malice, is deferral to the September BZA meeting. All those in favor?
Aye.
Thank you. Next case.
Case number V-11118-17-UP2 for use permit request to permit a setback of 18.5 feet to the existing deck from the 19th Road North right-of-way instead of 21 feet as required, and 9.5 feet to the existing wood steps for a 16 encroachment of the existing deck in R6 zoning district on premises known as 3181 21st Street North. Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions.
Thank you. Can I just ask a question out of curiosity? It seems uncommon to me that an architect would be the applicant as opposed to the owners. I'm not implying that it's not kosher. Maybe it is, but that's not something I've seen. We can ask the applicant, of course. Any other questions of staff besides the applicant?
Good evening, members of the board. My name is Sarah Riddlemoser. I'm the architect on the project. And I'll say that I'm here representing both homeowner and builder for what I would say is an unfortunate discrepancy that happened between a dimension on a plat submitted for last year's use permit and then the final survey that was done at the end of the project. I think it was a corner of the deck on the house that was existing on the original structure. The support structures, anything to do with the deck in that corner, were not moved. So essentially, the dimension taken for the use permit last year was taken at an angle that was different and not the closest point, which is what the 6-inch discrepancy became. So I'm here to assist my client and the builder to ask permission to have that deck and that corner remain.
Questions for the applicant? Mr. Owen.
Do you have a copy of the staff report in front of you?
I've seen it, yes.
Can you open it to the page that has the actual application? So I think it's the 6th page in, the one with a barcode at the top and the received notice for April 10th. So at the bottom of that, below the big black line on that page, it says owners' names, Andrea Briere and Michael Weissmuller.
Yes, correct.
There's writing on the signature line there. Whose signature is that? Or is there more than one signature?
The second line down, the signature? Yes, that's, I believe that's Andrea Briere's.
Okay. And then on that very same form, you're listed as the agent.
Yes, and I, to be honest, just offered to do the hearing for them. They came last year, attended for the first approval. So I told both builder and owner I'd represent, and staff didn't seem to have an issue with it.
Thank you.
The questions?
Madam Chair, I'm ready to make a motion.
Mr. Owen.
Madam Chair, I move that the Board of Zoning Appeals in case V-11118-17-UP2 adopt the attached resolution granting the use permit subject to the conditions stated below.
Second?
Moved by Mr. Owen, seconded by Ms. Malice to approve. All those in favor?
Aye.
Aye. Thank you.
Thank you.
Next case, please.
Case number V-11276-17-UP-1 use permit request to permit a setback of 1.5 feet for an existing elevated rear deck instead of 21 feet as required for an existing elevated rear deck in R27 zoning district on premises known as 2124 Brandywine. That's Brandywine Street. Staff recommend that the board defer the use permit to the July 2017 hearing.
Madam Chair,
Mr. Owen.
I move that the Board of Zoning Appeals defer the use permit V-11276-17-UP1 to the July 2017 BZA hearing.
Second.
By Mr. Owen, seconded by Mr. Smith to defer to July. All those in favor?
Aye.
Thank you. Next case.
Case number V-1277-17-UP-1 use permit request to permit a setback of 2.5 feet from the wall of the rear property line instead of 10 feet as required for a garage expansion in R10 zoning district on premises known as 2012 South Arlington Ridge Road.
Recommendation.
Staff recommends that the board adopt the attached resolution granting a use permit request with conditions.
Thank you. Questions for staff? Applicant, please.
Good evening. I'm Harold Leff. I'm the agent for the owners. The owners couldn't be here tonight. What we've got is a 81-year-old garage built in 1936. The outside measures 20 by 32, which is kind of a basic garage, but the walls back then were built 12 inches thick, solid brick. So the inside's only 18 feet. I drive an average-sized SUV. I pulled it in to see if it would work. My SUV is 17 feet. I got 6 inches in the front and 6 inches in the back. If I drove a Suburban, I couldn't close the back overhead door because it would not fit all the way in. Currently, the garage is 2.5 feet from the from the rear property line, although it seems like a side property line because this is a corner lot. So the side of the garage is 2.5 feet, and this garage measures 630 square feet. So if I were to increase the back of this garage 1 foot, which actually increases 32 square feet, I'd be over the 650 square foot limit, and then the existing garage would not conform to the setback. Right now the setback's 1 foot, but if it becomes larger, it gets a setback of 10 feet. So we couldn't even increase this thing 1 foot if we wanted to make everything fit. There's the third bay. It's a 3-car garage. The third bay currently has a set of stairs in it that goes up to a storage attic, and that stairs takes up the use of that third bay, so you can't pull a car into it. If we were able to increase this thing in depth, we could then relocate the stairs and we could actually use all 3 bays. The lot is oversized, almost double of what the requirement is. I believe the requirement in R10 is about 10,000 square feet minimum. This thing is 21,000 square feet. That's pretty much it.
Okay. Questions for the applicant's agent?
Madam Chair.
Mr. Owen?
It seemed to me when I went by the site that there's a tree right on the lot line that's very, very close to where your addition is proposed. And part of our, and just as background, part of our legal requirement for what we're supposed to examine is the impact on significant trees and foliage. And I'm wondering, actually, maybe I should first direct this to staff. I asked this question of staff earlier in the week, and they provided me with, which I hope that are now in the record, or could we put in the record, or could we make sure the applicant has a copy of any photographs that you sent me? Did you get photographs from staff in the last 24 hours?
I took these photographs.
You took those photographs. Well, even better. So can someone talk about the tree and whether or not it will live?
I can show you the photograph. There's not a tree there.
Staff was there.
Go ahead.
Staff was there yesterday on the property, and I took pictures of, you could see it on the PowerPoint. If you could see, there's a tree that's on the side of, on this property, which is close to the property line. And when I came back, I spoke with the owner this morning. I called the owner. The owner said he's not sure who is the owner of that, on which side that tree lies. So he is aware of the tree, but he said it's just a recent property. So he just bought it recently, so he doesn't know. The fence there was put by the neighbor, and he doesn't know if that tree is on his side or on the side of the owner of the neighbor.
Can you show the photograph that shows the front of where the garage doors are? That one? Yes. So the tree, I believe, is the one on the left side there of the garage. So that's over the top of the garage, and that on the screen now is a photo, and you can sort of see how tall it is and how much it goes, encroaches into the airspace of the garage.
That, I'm not sure. Do you have a PowerPoint of this one that I took? Because I'm not sure how far back that tree is. I don't see that near the property line. I see the foliage, but I'm looking at the picture that I took, and it seems as though that tree is pretty far back. It's pretty far back, pretty deep. We're only talking about going back 10 feet.
So, staff, do you also have a photograph from that same angle? I thought I remembered one in the material I received.
I do have some pictures, but I did not attach it on the slide.
It's kind of considerably over and much deeper.
It's hard to see.
There's one photograph from the same angle as the one that you're pointing to, the applicant is pointing to in your PowerPoint, but it was a color photograph, and so it was easier to see the location. Anyway, the photograph of the trunk shows it right up against the fence on your side of the fence, on the owner's side of you're there. See it's hard to see because it's in shadow, but you can see on the bottom of this photograph.
Down at the bottom.
Yeah. So there's the pavers, and then you see
The
trunk of the tree, but the trunk of the tree, you can see how it obscures the fence to the left, right? And so that's looks like maybe an 8-inch caliper tree, roughly.
Is that the front or the back?
It's in the back. It's in between the two garages, the garage that currently exists on your site and the neighbor's garage. It's almost exactly midway between them, the trunk.
So I'm looking at the back of the neighbor's garage?
No, you're looking at the front of the neighbor's garage from the back of your garage.
It's still
So if you're standing at the northwest corner of your garage, that's about where this photograph is taken from.
This fence is between the two driveways.
Correct.
So this tree that I'm looking at would be at the front of,
No, because the neighbor's garage is about 20 feet behind
Okay.
your garage.
okay. Well, if it's 20 feet behind,
So that means the tree is about 8 or 10 feet behind, right? And so that is what makes me worried that the tree is going to interfere with the construction of the garage.
well, when we were looking at this, we really did not see a problem with the tree, and I didn't see
So,
have you seen this?
yes, but I'm afraid the black and white photograph does not, it was not as helpful to my understanding as when I physically visited the site or the color photograph staff provided subsequently. So let me try this a different way. Do you think, so one thing that we could do that we might, I don't know whether I would have support on the board for this or not, but one thing that we could do is put a condition in the use permit that construction shall not result in the destruction of any trees over 5 caliper, right? And if you are sure that the construction won't impact any trees, then that's no big deal, right? But then the neighbor is protected in case, there's a dispute later about the tree coming down. So I wanted to see what your comfort level would be to accepting a condition along those lines.
The condition would be that we wouldn't destroy a tree
Over, say, 5 caliper, or I don't know what the right amount is, but small enough that tree would be covered.
Well, you're really putting me on the spot.
Sorry.
I mean, I'm the agent for I'm the agent for the owner. Well, I didn't see where the tree would be affected, so I guess we would have to agree to that.
And if it turns out that that's a, complete non-starter, there would still be the ability to come back before the BZA and make a case for that condition being removed, but that would be another round with the neighbor, presumably with greater understanding of exactly what was going to happen to that tree.
Well, if that's the condition, and if everything else gets approved with that condition, I'm guessing we could change the footprint and move our portion of the garage farther from that tree so that we only increase 2 bays instead of 3, and we work around the tree. We don't get as much garage as my client would like, but once our problem right now is if we do anything to this garage, the entire garage becomes non-conformant,
right,
compliant,
right,
and if I once I add on, if we get this variance, then the existing garage becomes compliant, even if I were to make the footprint smaller if I had to. So yeah, I guess we would accept that.
Thank you.
You're welcome.
Madam Chair, I'm sorry, go ahead.
Just wanted to clarify, is there any doubt on the part of staff or you as to whose property that fence is on?
Yes,
There's doubt?
yes. I spoke with the owner. I called him this morning. He's not sure on which side that tree is.
Yeah,
He confirmed that the garage will not impact the tree. That was his conclusion.
is any of this construction going to happen on his property?
It's according to the plat provided.
No.
It's on
According
the
to the-
applicant's property.
Plat.
Right.
The fence is on the right person, is on the property of the applicant.
According to the plat, the fence is half a foot onto our property.
Half a foot onto
It's
your
0.5.
property.
It says on 0.5, and then the garage, corner of the garage is on 2.5.
Okay, so your applicant the owner just needs to be, this needs to be cleared up with the owner so he's clear in his mind of that question.
We were going by the plat when we submitted this. We were going by the plat, and it's a recent plat. It's only 3 years old. And there was a previous plat that was extremely similar to this that I looked at and conferred with.
I'm prepared to make a motion.
I just make the observation that I would feel more comfortable if the owner was negotiating.
I would prefer the owner negotiating, but he's on
Well, I'd
travel
also
and-
like to know if this is just a nice shade trash tree or if it's a really, worthy tree. I mean, but that's just my observation, that it's a little bit awkward situation in which we find ourselves. I don't think it's cut and dried.
Yeah.
Ms. Malice.
If the alternative is that we defer it until the owner has an opportunity to engage, and I'm not sure that that's useful. I mean, that's the alternative.
I mean, eyeballing it for myself, my sense was that the trunk was not in jeopardy. And so it was just a matter of how much the roof was going to clip major branches. And so I will be surprised if you wind up running afoul of the condition. But because it's difficult to be certain, that's why I asked. And particularly because it might be your neighbor's tree, right? Like that's on my mind too.
Okay.
Chair, I'm prepared
Mr.
to make a
Owen.
motion. Madam Chair, I move that, I'll offer an amendment after I make the motion, but I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V-11277-17-UP1, subject to the conditions listed in the resolution.
Second?
Madam Chair,
Moved by Mr. Owen, seconded by Ms. Malice.
Madam Chair, I would offer an amendment, an additional amendment number 4, to say, applicant agrees that, sorry, just making a note here.
I assume you mean 5. They're out of order, but there are 4 conditions, not amendments.
And they're not in numerical order, so that was what threw me off. New condition number 5. All right, so I'm starting afresh. I offer an amendment to add a new condition number 5. Applicant agrees that construction will not result in the destruction of any tree greater than 5 inches caliper. So that should offer, I hope, sufficient latitude to keep you in the clear.
I don't want to be out there saying.
Seconder of the motion, accept that.
You want to vote on the amendment?
I'm just offering as amendment a flat-out normal amendment.
Okay, then I would second the amendment.
Okay. The amendment is to add a condition regarding destruction of the caliper of the tree, 5 caliper. All those in favor?
Aye.
Aye.
Thank you. Now, we have the main motion with 5 conditions. All those in favor?
Aye.
Thank you. Good.
Just, thank you.
Next case, please.
Case number V-11278-17-UP-1. A use permit request to permit a setback of 6 feet to the wall of a 1.5-story garage to the rear property line instead of 10 feet to the rear property line for a 1.5-story garage in R6 zoning district on premises known as 2531 Key Boulevard. Staff recommends that the board defer the subject use permit request to the July 2017 hearing.
Madam Chair? I'd like to make a motion.
Please.
So I move that the Board of Zoning Appeals in case V1127817-UP1 that we defer the use permit in that case to the July 2017 BZA hearing.
Second.
Moved by Mr. Melnick, seconded by Mr. Owen for deferral to July 2017. All those in favor?
Aye.
Aye. Thank you. Next case.
Case number V-11099-16-VA3. Variance request to permit a setback of 4.5 feet to the wall of the existing home from the left property line instead of 8 feet as required, 5 feet to the eave, 6.4 feet to the wall of the proposed 2.5-story rear addition from the left side of the property line instead of 8 feet as required, and 5 feet to the eave, 9.4 feet to the 1.5-story right side addition from the right side property line instead of 10 feet as required, 8.1 feet to the wall of the 2.5 rear addition from the right side property line instead of 10 feet as required, 6.5 feet to the eave and 19 feet to the rear deck instead of 21 feet as required, and an aggregate side yard of 13.6 feet instead of 18 feet as required for a new 2.5-story rear addition in RA8-18 zoning district on premises known as 2116 North Culpeper Street. Staff recommends that the board defer the variance request to the July 2017 hearing.
Motion?
Madam Chair?
Mr. Melnick.
So I'd like to make a motion in this case. So I make a motion that in case V1109917VA3, that the Board of Zoning Appeals defer the subject variance permit to the July 2017 BZA hearing.
Second.
Madam Chair?
Mr. Owen.
I just want to put into the record that I posed some questions to staff on this. We've heard in the past on this site that the neighbors have a great concern about the sidewalk configuration here. And so I asked staff during the deferral period if they could ask Department of Environmental Services what their plan is for the sidewalk, whether there's planning documents such as a NC permit, what the precedents are for easements being required as part of a zoning, as part of a variance application or approval. And I think that was it.
Madam Chair, I also, since this is a deferral, we don't have staff's recommendation. So, and I don't know if staff has a recommendation at this point, so we don't know which way you all are going. I just would want to know what options does the owner have for this site outside of this variance that they're requesting. So is there a by right option? Is there any other options? And I would just for next time, if you could have that information so that we can compare this to what other rights they have on this site.
Madam Chair?
Mr. Owen.
Just to further elaborate, I'm also curious about Ms. Malice's question. RA 818 has quite a number of special exception permit, use permit and even site plan options. Many of them, you have to have a certain size site in order to qualify. It wasn't clear to me in particular whether or not use permit townhouse was permitted on this site even at its current size. But I think it might be helpful to just have a rundown of all of the different by right and use permit and site plan possibilities and what their minimum requirements are, and if any remain other than what's being proposed, as Ms. Malice asked for.
Okay, we have a motion on the floor to defer to July. All those in favor?
Aye.
Thank you. Next case, please.
Case number V-11279-17-UP-1. A use permit request to permit a setback of 1.1 feet from the wall to the rear property line instead of 25 feet as required, and 1.1 feet from the wall to the right side property line instead of 10 feet as required for a new 2-story accessory building in R6 zoning district on premises known as 1704 South Lincoln Street. Staff recommends that the board defer the subject use permit request to the July 2017 hearing.
Madam Chair,
Mr. Owen.
I move that the Board of Zoning Appeals defer the subject use permit request to the July 2017 BZA hearing.
Second?
Moved by Mr. Owen, seconded by Ms. Malice. All those in favor?
Aye.
Thank you. That concludes the agenda. I'd like to take a few minutes before we close with a very brief discussion of the topics that you would like to discuss at the work session, which is scheduled to be at 6 p.m. on before the August BZA meeting, which is what? The 9th? August 9th. Note that, please, start time, 6 o'clock. We've talked in the past about issues of notification. And so we'd like I for one would like some clarity about such things as when is the final agenda ready? Who is responsible for posting? And can we get some commitment for posting that is considerably sooner than the Monday before the hearing? In addition to which, I have some concerns about the responsibility of applicants, not only to reach out to their neighbors, but to keep them informed of such events like tonight, where we had a number of deferrals. The word appears to have gotten out. But we have had cases in the past where people have shown up to speak, only to find out that the agenda had been changed. So I throw those out for things that I'm concerned about, so that we spread the responsibility, but that we take very seriously the notice of the issue of posting.
Madam Chair, just to build on that.
Ms. Malice.
I guess once some of these things are established in terms of process, it would be good if they could appear on the BZA website so that applicants know what their responsibilities are, or neighbors know what to expect. I'd like to, include the notification letter, a review of the notification letter that neighbors get, because I've been told that they may get a hearing date, but they don't know whether they can testify, kind of what, where the materials are, where they should direct their attention. I think, that's just, a legacy. I think all of our county websites are much more informative in that respect now, and it'd be just a housekeeping task to raise our website up to the same standards so that people know, and the notification letters that, yes, you can come testify, yes, you can present evidence, yes, whatever we decide are the rules. And further, I'm interested in sort of the notification process. What is the legal requirement? And is what we're doing the legal requirement, or is our practice beyond that? Are we going to best practices in terms of notification? So one is, what is the minimum legal requirement of notifying neighbors and putting placards on the, and which are county
Policies.
in practice, so that we kind of know where we stand on these things.
Other comments?
Madam Chair.
Mr. Smith?
I'd like to ask staff if it's possible that each applicant be sent via email a copy of the staff report when it's published.
Thank you. Other comments?
And that was going to be my comment, too.
Okay.
Madam Chair.
Mr. Owen?
Well, another comment we heard at the last meeting was that neighbors didn't get much more than that there was an application at the property, but they didn't get to see the application until the staff report was ready. And so one thing I would be curious about is the feasibility of putting the applications up sooner than the staff reports.
On the website?
On the website, so that the neighbors would have a greater appreciation of what's being requested. Yes.
Come in and look at any application at any time. You know that, right?
Yes. So in the government agency I work at, that's one of the talking points that I've been given to defend our agency against not putting certain things online. And I've been told that the legislative body that I work with doesn't accept that anymore, that it's 2017 and things are either online or they don't exist. So, so I appreciate where you're coming from. I think I'm sure that I have seen other jurisdictions BZA or zoning variance applications where the applicant is asked to themselves identify the properties that abut them. And I think I would be interested in everyone's idea about whether or not that might be a helpful exercise, that is making part of the application. You tell us who your neighbors are, what their addresses are, that might further drive home into the minds of applicants. To have a complete application, you have to successfully identify who your neighbors even are, and that would be the first step maybe to communicating with them.
Madam Chair, would you say ID by name?
No, by property address. I'm sorry, that's...
I would suggest that to make that effective, I agree with you that that's a good practice, that's a good activity that should educate them and give them opportunity. But I think that in that education process that they tell us what is the name, so they've gotten the name of that neighbor, not just, I talked to him, I see him, I wave hi, but their name is,
I'm sorry.
Smith.
My response to you, Mr. Smith, just a moment ago was perhaps unclear. I was merely saying that what I observed elsewhere was that they asked for property addresses, not that I've concluded that that's better or worse than the names. So
Gotcha.
helpful clarification.
I think because you have rentals and you have absentees and all kinds of stuff, I think the point would be that we're interested in making sure that they know that it's important to identify the adjacent property owners, including the ones behind and the ones across the street, and because that follows up with what we want in the way of feedback.
As we've talked about before, I would like to know both the legality of and the feasibility of requiring as part of the application an acknowledgement of receipt by the applicant of the BZA's hope and expectation that they will actually have talked to their neighbors. So again, I'm clearly distinguishing that from saying you are required to talk to your neighbors. It's not what I'm saying, but I'm saying you are required to agree that we told you to talk to your neighbors.
Well, we've produced a letter from the chair before with a request that that be shared with the applicants. I don't know, that's part of this work session can be, has that ever even happened, or what is it, you know, how is, if at all, is that intent communicated?
And so my supposition is that perhaps one time to give it to them is before they even file, and require them to sign the bottom to say, I got this, right as they file, so that they have the longest possible time to use that information. I'm curious about the practices for civic association notification. I don't know whether that's legally required or that's just an extra thing that we do. I remember when I was a civic association president, I got notices of BZA hearings. I did notice in the most recent agenda that there seem to be some mismatches in terms of the names of the civic associations.
They tend to, sometimes they put in the subdivision instead of the civic association. Yeah, like the Wynwood thing. There's no such thing.
Okay.
That's a subdivision. I don't know why that happened, but I noticed that because I knew the neighborhood.
So I would be curious about
Road also.
I'd be curious about those practices and how that all works. And Madam Chair, I guess two other things just about our own process, and maybe this wouldn't need to be something we talked about in August, but maybe we can talk about it at some point. Excuse me. Several of you have served on the Planning Commission. I've served on other county commissions, and the counties, those other commission practices, and the county board's own practice is that the chair is not burdened with naming how many speakers there are and calling their names. That's something that's handled by the secretary or the clerk. And I wonder whether or not taking advantage of the additional staff in the room to help with that would be something that would be nice for us.
Usually done by the staff.
Yeah. I don't, either way, I don't have an opinion. I mean, I don't consider it a burden that, you know, that even if we have 10 or 15 speakers, when we had the gun people, that was a bit much, but even so, they got themselves organized, so they didn't actually all speak.
One advantage of I think there's some advantages to that, and we can, whenever you want to talk about it, so perhaps we could talk about it in August, but I have some thoughts about why that might be advantageous, especially at contentious hearings. I think it's advantageous.
Well, we've had some discussion that is off the subject, but about the subject of BZA staff, and whether we have staff or we're staffed by the county, which appears to be the case, and what those, but it certainly could be, that the staff reads off the names just as well as anybody else does, or gives them, whether they give them the slip to me or not, it doesn't really matter.
I think it adds a certain social distance sometimes that allows the chair some greater authority to keep people in line if emotions are running high.
It's not a
problem. And then I also wonder about our practice when we have a variance and a use permit for the same parcel on the same night. Our tradition is to hear the variance first, conclude it before we hear any evidence on the use permit. And I'm curious about whether or not that's a practice that's required by law, followed in other jurisdictions, because sometimes I feel like there's information that's presented in the use permit part of the application that might be relevant to the discussion we're having about the variance. And so getting it in the record before we vote on the variance may or may not be helpful, and I'm just curious.
I assume that's a county attorney question, but here again, not part of the notification issue, but that's okay.
So those last two, I don't, Madam Chair, I leave it to you. You're the agenda setter for us, right? So if you would prefer to leave those off the next meeting, I'm cool with that, but I didn't want to not say them in case you did want to talk about them.
Well, I think my concern would be that we're raising some issues. We're going to have an hour. I don't think we should muddy the waters too much. I think that the staff could certainly answer some of those questions directly to us by email or handout or whatever, particularly if there's a legal requirement that variance and use permit be heard separately. Then I think part of the issue with that, at least in my recollection, is that in some cases, the discussion part of the staff report, even in a variance, will address the reason for the variance. In other words, there is an associated use permit for X, not just that there's an associated use permit, period, and there's no information. So a lot of times the staff can or does give enough information, and then of course there's the option to just read ahead and figure that out. So, but I would say let's for August, in order not to have it be too burdensome, let's stick to the issues of notification, and to the extent that you can give us some information ahead of time, so that we come prepared to expeditiously blow through it, that would be great.
Madam Chair?
Ms. Malice.
This may fall into the area of not for August, and it may be something that's not entirely for staff, but as I'm thinking about all these process issues that we're going to sort of clarify and discover and legalities, the issue of accountability comes to mind in terms of who's accountable for ensuring that things happen. Is it staff? Is it the BZA? Sort of where do we draw the line? And so as I was trying to figure out sort of where things stand, I recognize that BZA appoints a secretary, but that's it. But that secretary happens to be the same person in practice who's the BZA coordinator. And so I'm trying to understand, what is the role of the secretary? Is it the secretary's job to ensure that these process questions are properly handled? And by secretary, I mean, the person that sort of it's not staff hours. But if the secretary's job is to write the minutes and make sure that the agendas are correct, is that the limit of their job, or do they have a responsibility also to make sure that things are posted? Or is that a function of the government, which is sort of the BZA coordinator or our LOVIS staff? And that's a question I don't know if staff has an opinion on. I'm not sure where, some of it's in the code, some of it's, I didn't know what the county zoning ordinance says. But it's sort of just I'm trying to get oriented so that when we say something's not happening, is it our responsibility to make sure it's happening, or do we take, is it the government's job to make sure that it's happening? Because we're not the government in this case. So if staff has an opinion on this, if you've given thought to this, I'd be interested to know how you see what the secretary's role is versus the BZA coordinator's role is. But I don't know if it's also a legal question, that the county attorney says this is the secretary's role versus the government's role, or is it a question that we direct to the courts, to the clerk of the court that says, from the court's perspective, this is what your role is, and the secretary that you appoint role is. And so I see it like three different resources to look at, and I wondered, since I don't expect staff to call the clerk of the court and ask all these questions, whether this is something that we can investigate on our own and bring back information on, or how would we sort of clarify this? So I guess it's a bigger question.
Yes, I have no idea. But I think that you have some information, or the county attorney might have, in terms of what the requirements are, staffing requirements are, who has the responsibility for what.
We'll certainly start there.
Okay.
Yeah, and get back to you with.
Okay.
Hopefully it's something that we can document for you and perhaps future board members so that it's clear.
Great.
Yeah, just because because our role is to appoint the secretary, but it's like, why? Or
The state legislature gave us that responsibility.
Right.
And what is the state legislature expecting for us in terms of diligence and care in doing that?
Okay, are we clear about the topics that we'd like to address for August? And everybody's noted that it's 6 o'clock? August 9th? Okay, good. Thank you. We have minutes, first from April. I note any number of comments from Mr. Owen, but I don't know if they've all been incorporated into the minutes or not.
Did we not approve the April minutes at the May meeting?
I think you had corrections to the April minutes at May.
Right, but then didn't we approve those?
I guess they were sent back so that we could verify they're correct and get them signed tonight.
Okay, I don't have any changes, but I don't.
I didn't even look at it. I presume that it was ministerial.
Got it.
To show us how you did it.
Changed. Yeah.
Okay, can I have a motion on April?
Madam Chair, my view is respectfully that we don't need a motion for April, that we've already acted on it.
Does everybody agree with that?
Well, it looks like, Madam Chair, looking at page 18 of the
May.
May minutes,
It says that April was approved.
that's what it says.
Okay.
Except it shouldn't have been a 5-0 vote, because I would have abstained because I was absent.
Well, there's your first correction.
Okay.
Madam Chair, if we're now on the
We're on May.
question of May, I emailed to both staff and my colleagues on the board a couple of corrections. So near the end, on page 16, so on page 16 with that one, in listening to the tape, the most significant change is that condition number 7, I did not actually hear that as part of the motion. We discussed maybe doing that at some length, but I think when the final motion came, there was no actual amendment to do number 7 at all.
Madam Chair, after seeing Mr. Owen's comment, I went back and listened myself, and I have to say that I did not hear myself make that motion. I agree that we discussed it, and then there was this quiet part, and I think it's almost like a little collaboration here of my saying, I don't know if I want to make the motion or not, but clearly there was no motion read into the record.
Okay, so you want condition number 7 deleted?
Yeah, I don't think that I said those into the microphone out loud.
Okay.
So then the second thing is that the motion for number 6, I think, was differently phrased than what's printed in here. And so what I heard on the tape was the applicant shall retain an arborist to review the conditions of the trees and make recommendations as appropriate prior to the issuance of the building permit. So substantively similar, but not exactly the same as what's here. And again...
Incorrectly spelled.
Yeah. For condition number 5, there's a more substantive... Well, I think there was a substantive difference on 6 too, but for number 5, the motion that I made included not just the name, but also the email address and telephone number of an individual to receive inquiries from neighbors affected by construction. And all those words were important to me in adding that condition. Just a typographical thing, I guess it's traditional in the minutes to underline language that differs from the staff report, and so I would suggest underlining the revised date in condition number 4, which it took me like 5 tries, I think, to get the date right, but I appreciate everyone's help in getting that done. And then as a result of all of those, I think there's some modifications to the introductory language that describes how there was a motion and then an amendment offered by Ms. Malice to adjust the introduction.
Is that it?
That, I feel like I had one, oh, I did have one other. So that, on that item, those are my edits. And then I had one other smaller edit on a different item. On page 8, in the introductory comment, I think it might be clearer to say that, well, first of all, the initial motion was to adopt an amended resolution, not simply to amend the resolution. But also, I think it would be helpful to clarify the rationale for striking all the language was to not grant special relief for the front yard fence. So I propose adding that language after the word pool in the material right before the word resolution on page 8. So it would read then, and there being no other speakers in this case, Mr. Owen made a motion to adopt an amended resolution eliminating the requirement for a 6-foot fence around the pool, but not granting special relief for a front yard fence.
Okay, and you've given this all to staff to
Yes,
make changes?
yes, Madam Chair, I've sent it by email to staff.
Okay, so is,
But I did not send the one that Mr. Smith mentioned for the approval of the minutes on 4-0 as opposed to 5-0.
okay, so do we wait to have these
So I think it's,
edited?
if you're comfortable with the statements made, I think you can vote now, and it'll be
As amendment?
as amended, and we'll, in terms
Okay.
of signing them, we'll bring it back next month for you to sign.
Okay, so can we have a motion then?
I move that the minutes of the Wednesday, May 17th, 2017 meeting be adopted.
As amended.
As amended.
Okay.
Second.
Moved by Ms. Malice, seconded by Mr. Owen to adopt the May minutes as amended. All those in favor?
Aye.
Aye. Thank you. Adjourn.
4 hours earlier than last month.
We have a motion to adjourn.
Move to adjourn.
Moved by Mr. Smith, seconded by Mr. Melnick to adjourn. All those in favor?
Aye.
Thank you.